and welcome to the latest episode of History You Didn't Know But Should. I'm Ray.
And I'm Chris.
And today we're going to be looking at the Supreme Court. And this is a very timely episode as Associate Justice of the Supreme Court Stephen Breyer has announced his resignation, and President Joe Biden is in the process of thinking about who he might nominate for his first nominee to the United States Supreme Court. Stephen Breyer, of course, is Associate Justice of the Supreme Court. He has served on the court since 1994. He was nominated to the court by President Bill Clinton. So he is going to be stepping down, I believe, at the end of this session of the court, and a new justice will go through the process. And I think, Chris, today, that's really what we want to look at, is the process. How does someone go from being appointed by a president to being approved by the Senate and becoming a member of the Supreme Court?
Yeah, Ray, this is something that happens very infrequently, but yet it is probably one of the most significant parts of American politics. And whenever a sitting justice retires or passes away, this causes American politics to just stop as everything centers on the court, because there's only 9 of these and it's a lifetime seat. And so when a president is given the opportunity to nominate a particular person to be on the court, this is going to have ramifications, not just for that president's years in office, but you're talking about for a considerable amount of time. And, you know, if we start thinking about this, I think we could probably say for the president, the appointment of a Supreme Court justice can be the legacy of the president, more so than what they did on immigration or crime or the budget or even a COVID. Everybody will remember the person you selected or persons you selected for the Supreme Court, because that person will probably serve on that court much longer than the president will be in the Oval Office.
Yeah, and you think about that, I'm looking at a list of Supreme Court justices. John Paul Stevens, who was appointed by Gerald Ford in 1975, served 34 years on the court. Sandra Day O'Connor, of course, appointed by Ronald Reagan, 24 and a half years on the court. Antonin Scalia, of course, who passed away in 2016, 29 and a half years on the Supreme Court. Clarence Thomas, who right now is the oldest serving justice on the Supreme Court, 30 years on the court. And of course, he was appointed by George H.W. Bush. It's interesting to me that that all the other justices on the court right now were appointed by George W. Bush, Barack Obama, and Donald Trump, except Breyer, who of course was appointed by Clinton. So once Breyer's gone, all the justices will be appointed by George W. Bush, Barack Obama, and Donald Trump. So this is a very young court at this point. I mean, I think the max, once Breyer's gone, the max will be 16 years.
And just think about what has occurred during the times that those people have been in office or sitting on the bench, the decisions that have been made, because the Supreme Court is the supreme final say of whatever it is that needs to be done when it comes to understanding the Constitution, thinking about, if certain things are constitutional. I mean, it comes to the Supreme Court. So the Supreme Court is the highest law in the land. So for our listeners, I mean, you can take your case to district court, and if you're not happy, you can go to an appeals court. And if you're not happy, you can, eventually make your way to the Supreme Court, which, by the way, is very unlikely to happen. Right. So any case that gets to the Supreme Court has very important, life-changing impact on all citizens in America. You think about Roe v. Wade. That's a huge topic that is being discussed right now. And I think it's being discussed so much because of President Trump and the opportunity he had in naming individuals to the Supreme Court. We'll talk about that in just a few minutes. So, you start thinking about this, it's a legacy builder. I'll mention President Trump. He will go down in history with a lot of negativity, a lot of things against him. But the one thing that he will be known for his legacy is how many people he brought to the court and the legacy of the decisions that those individuals make. 3 individuals. And I go back to John Adams. John Adams, of course, second president of the United States. And John Adams, I believe it was John Adams, one of his quotes, he said, my gift of John Marshall to the Supreme Court was the proudest act of my life. That all of these things that John Adams did, I mean, he was the one who represented the British soldiers in the Boston Massacre. He's the one that succeeded George Washington. He's the one that got into, very controversial election with Thomas Jefferson. Nope. But what's to him the most proudest moment was putting John Marshall on the Supreme Court. And think about the legacy, because it was John Marshall. If you think about it, he was there, I think, 34 years. He did more than any individual that's ever served on the history of the Supreme Court in crafting and defining what the Constitution really means for us today. So what President Biden is getting ready to do is extremely important, and all of us need to be paying attention to what he's about to do and how he's about to do it, and all of the things that kind of go into that.
Yeah, when you think about founding justices, of course, John Jay was the first Chief Justice of the United States Supreme Court. But Chris, I think it is fair to say that John Marshall, probably had more influence over the court as it would move forward than Jay did.
Oh, absolutely. I think there's no mistaking about that, especially if you go and look at some of those early court cases, which, unless you're somebody who really, really likes the court and politics, some of those early decisions were not that sexy, if you can say that, but they were extremely important. Go back to Marbury versus Madison, which pretty much gives the courts the authority to check the Congress and ensure that Congress isn't just making a bunch of laws that do not protect the liberties of citizens. So there's all kinds of those things. So, I absolutely agree with you on that.
Yeah, and the court, as you've already mentioned, and there with with Marshall, the court definitely plays a very important role in judicial review and in that checks and balances within the federal government. Now, of course, the Supreme Court was established by the United States Constitution in Article 3, Section 1. It says the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. So the Supreme Court, when we look at the federal courts themselves, the Supreme Court is actually the only court mentioned in the Constitution, specifically in Article 3, which deals with the judiciary branch.
Yeah, and then so you have the creation of the court, but the other thing that you had to have was, well, how do you get the court? Mm-hmm. What's going to take place? And the fascinating thing is that all of this is being done from scratch. These framers, as we like to call them, are kind of creating this on the fly as far as, well, okay, so we know that we need to have a Supreme Court, but how are we going to get there? Which is kind of where, if you go back to, I think it's Article 2, which they then give the power of nominating these individuals to the President of the United States, with a catch that the President of the United States has the right to nominate individuals, but Congress needs to have a part in that as well, especially the Senate, which is to do something called advise and consent. I think that's important because what the framers were trying to do is ensure that there's always going to be checks and balances, that everybody has a role in allowing this thing to come to fruition. But it's also a design to make sure that the court checks Congress, Congress checks the president president checks, that they all are there together, kind of balancing each other out.
Yeah, advice and consent of the Senate, what exactly that means, how exactly that's played out, is something that has changed over time. Our listeners may be interested to know that the hearings that you have often aired on CNN and C-SPAN, et cetera, during a Supreme Court nominating process, those hearings didn't begin, I believe, Chris, until 1916. When I guess it was President Woodrow Wilson, am I correct on that, that nominated someone who was seen as being somewhat controversial, and that's where the idea of these hearings began. Before that, nominees simply got up or down votes from the Senate. So exactly what it meant to have advice and consent. And of course, advice and consent isn't just with Supreme Court justices, it's with other things such as appointing ambassadors, public ministers, and other officers in the United States. Of course, we think about members of the cabinet, like Secretary of Homeland Security, Secretary of State, Secretary, other secretaries within the presidential cabinet. You have the advice and consent of the Senate on them as well.
But I think we also have to look at, what does advise and consent mean?
Yeah.
I mean, it's and throughout, we always, and the beauty of this is we have to kind of go and read through the tea leaves and try to understand what these framers were really wanting. Why did they want there to be this concept of advise and consent? And, I think that kind of what it means is it's to protect the president. Yeah. So that the president nominates someone that's not the good old boy network, like, well, that's my boy, I'm just going to nominate him, and, I'll slap him on the back and he'll become, a sitting justice for life, where the Senate can come in and say, well, sir, ma'am, that's not the wise decision. You need to select someone who's got high professional qualifications, someone who's got integrity. And so, our job is to kind of advise you on the best people at the best moment to do. However, the advice is not binding. That they give the advice. President can choose to accept it or not. But what you have to remember is the president is going to recommend that candidate to the Senate, and the Senate ultimately is going to do, as you said, thumbs up or thumbs down. So if you just totally disregard the advice of the Senate, there's a really good chance that you look bad, because your candidate is going to fail, because they ultimately have the final say. By the way, the Senate, and it is a majority vote, so it's not like you have to have 2/3, but I think there has to be this working part with that. And as you mentioned, all of those committees, all of those hearings, that's now known as the Senate Judiciary Committee.
Right.
And that's where you get the fireworks. And that's where, you start seeing all of these things. But Ray, that Senate Judiciary Committee really wasn't designed for the fireworks that we saw with Kavanaugh becoming a Supreme Court justice, or Amy Coney Barrett becoming a justice, or even let's go back to Robert Bork or Clarence Thomas, because all of those had moments in which it was live TV where everybody's stopping to see. It shouldn't get that way, because before you get to that place, these individuals have gone through a strong vetting process. They've been interviewed, they've background checks. I mean, you have everybody from the Secret Service, IRS, and all kinds of other people checking out these people to make sure that they're legitimate, qualified candidates. But once again, the senators wanting airtime, wanting to make themselves look good, have a say, they start putting their own spin on this. And Ray, I'll stop on this part right now. We need to remind our listeners that the Supreme Court is supposed to be nonpartisan.
Right.
It's not supposed to be political, that you shouldn't have Republicans and Democrats. But the reality is, depending on the party of the president, is pretty much going to depend on the person who becomes nominated will be somebody who supports that president's views.
Yeah, and especially since TV cameras came into the hearings. Once TV cameras came into the hearings, those hearings became an opportunity for politicians to make speeches, not just to ask a quick question. Well, this is a question I have for the nominee, but to make speeches and to try to catch the nominee in publicly embarrassing or contradictory answers.
And the current president of the United States, who was very heavily involved in having those particular moments, because he was a senator from Delaware and he had a lot of strong opinions and, as you mentioned, speeches that he now has to go back and be very careful with the person that he's introducing, since he was on the other side. So this president has a really good understanding of how this process works, because he sat on the side of a senator on the Judiciary Committee in dealing with some very controversial candidates. And now he's president, understanding that he has something that, is going to determine his legacy also. So I think he sees both sides of it. It'll be interesting to see how he goes forward with that, knowing both sides.
And it is interesting that a person can be nominated to a federal court, approved by the Senate, and then they get nominated to the Supreme Court, and that approval process becomes far more difficult. It's one thing to be nominated to a regular federal court, but it's another thing altogether to be nominated to the U.S. Supreme Court.
Yeah, and do you, as we think about this process beginning, President Biden has been given something that is going to determine his legacy, as we said, and it's pretty interesting. Prior to Biden's presidency, the 44 other presidents that were here, 6 of them had the opportunity to make one Supreme Court nomination. They had one. But I found this interesting, that Presidents William Henry Harrison, Zachary Taylor, and Jimmy Carter did not have the opportunity to make one nomination to the court. It's interesting to me because those 3 individuals really don't have a legacy that goes beyond a lot of crisis and a lot of other things. And if you think about Franklin Roosevelt during his, and he was president a lot longer than everybody else, but during his 5.5-year period of his presidency, he filled 9 vacancies on the court. And if we were to go back and look at how many years those people served, all of his New Deal programs, all of the things that come out after that, that just shows you how powerful the president's legacy becomes by nominating someone. And of course, President Trump, we've already mentioned him. He had the opportunity to do 3. That's unheard of. And that caused controversy as well, because, is it right for a president to put 3 members out of 9 on a Supreme Court who are going to be focused on your party preference and who can dictate the course of history, which is why I think a lot of people are worried about certain cases and certain precedents, such as Roe v. Wade and things of that nature, because there's been such a political turn into the court recently.
Yeah, especially since Donald Trump lost the popular vote in 2016. George W. Bush, who was the most recent president to lose the popular vote, of course, he lost the popular vote in 2000. He didn't get a chance to nominate anybody to the U.S. Supreme Court until 2005, which was the beginning of his second term. And he did win the popular vote in 2004. So when he nominated John Roberts and Samuel Alito, he had the support of the American people, in the sense that they had voted, the majority of people who voted for George W. Bush. With Donald Trump, of course, he only served 1 term, but in that 1 term, he came in as, quote, the wrong winner, end quote, that he did not win the popular vote. And going back to, those 3 presidents who did not nominate anybody, Jimmy Carter, I didn't know that he didn't nominate anybody, but it doesn't surprise me. William Henry Harrison, man was only in office 30 days, so he can't do much. And he was sick most of that time. And of course, Zachary Taylor was an incomplete term as well.
But
presidents, like
I want to say,
wants to nominate.
Yeah, I'll go back to that William Henry Harrison comment, though. Sure, he's there 38 days, but go back and think about the time as far as vacancies and things of that nature, and how quick it can happen, and also how long it can happen. There's been some that it's taken forever, for the person to nominate someone, and then it goes through the process and do things like that. But if I can't remember exactly, but like President Trump, he, as soon as there is, I think it was that was the Ginsburg, right? When Ruth Bader Ginsburg passed away.
No, are you talking about the first one or the last one?
The last one.
Well, the last one was when Ruth Bader Ginsburg passed away. But remember when Barack Obama was president in 2016, and like early 2016, Clarence, well, no, it was who was the guy who died? Antonin Scalia died, and Obama nominated Merrick Garland to the position, and the Republicans refused to approve him. They didn't even give him an up or down vote. And so Trump comes in and he appoints Neil Gorsuch. But the last one Trump did was Amy Coney Barrett.
And how fast it was. I mean, and that was because the election, right? And that was that whole controversy. Should you nominate someone when you don't know the results of the election? Should that wait until you find out who wins the election? And I think Trump was afraid that he might lose the election. And so he wanted to go ahead and put somebody on the bench. Once again, 3 people, that's your legacy. That sounds pretty good. So he kind of says, and he had the legal right to do it. He had the right to do it.
Yeah, but the Republicans, Antonin Scalia died in February 2016, and the Republican Party at the time said, "Oh, it's too late. We can't nominate. We can't approve anybody before the November election." And here you had Ginsburg dying in September on the election year, September 2020, and all of a sudden it's a rush to get her replacement placed on the court.
So we have this process that's happening, and so Justice Breyer has retired, and basically in his letter, he shared with the president, "It is my expectation that you will nominate and approve of a particular candidate before the current term ends." And so the current Supreme Court term will end in June. That's usually June, I think the end of June, by July 1st. So President Biden now has already stated that it's his hope to have a person nominated, his recommendation, by the end of February. Yeah. And so he'll nominate that person, whoever he thinks is the best qualified, and then it will go to the Judiciary Committee. The Judiciary Committee will have their moment in the sun. They'll have their 5 minutes on camera to make their political speeches, because honestly, they don't ask a lot of questions. It's mostly just, making myself look good and for the remaining time. And then the Judiciary Committee, if they approve, it will go to the Senate. Senate, has the opportunity to debate it and to talk about it. But usually if it gets past the Judiciary Committee, there's a really good chance that the Senate is going to pass it. And then after that, you have your Supreme Court justice. So the process is pretty simple. It's pretty straightforward, but there's so many politics that are in it. And that's why, it's going to just be interesting, because our political culture right now has a hard time agreeing on anything.
Yep.
And so you really feel bad for whoever it is that's about to be nominated, because half of the country isn't going to support them, no matter what. Mm-hmm. I don't know if half the country will support them, not because they're not qualified, but because of the political climate that we're in, even though this is not supposed to be a political appointment.
Yeah. And yeah, exactly. Half the country, 50% or maybe more or slightly less, are going to vehemently oppose whoever is nominated. And that's unfortunate, because then the person goes on the court with at least half the country not liking them. And I can't think that's a healthy thing for the democracy or for the court.
It's not. And I'll give you a perfect example. So the Supreme Court's been meeting for the very first time. They've come back since COVID, and they're actually meeting in in the chambers. So they're actually in person hearing oral arguments, and then, they'll start making their decisions. And what happened was there was a reporter who observed that Gorsuch was arriving to court maskless. He wasn't wearing his mask. And I can't remember if it's Sotomayor or Keegan, but one of them has some serious health issues. And Gorsuch sits right beside them. And all of a sudden, this reporter started making this really, really big deal that the Supreme Court justices were fighting with one another because Gorsuch wasn't wearing his mask. There was a health issue with the other justice, and made it to be something that it really wasn't. It later came to find out that the reporter said a bunch of hearsay that really didn't matter, and it caused, I think, John Roberts to have to come out.
And didn't the other justice, whether it was Sotomayor or Kagan, didn't they come out and basically say there's nothing to this?
Yeah, they said there's nothing to it. We're friends, there's no issue here. But it just shows you the dynamics here.
Yeah, and something I think a lot of people, while we're talking about, how in the current poisonous political climate, Supreme Court justices come into office with at least 50% of the country not liking them. It's important for us to remember that there's only 9 of them. And if you're on the Supreme Court, there's only 8 other people in this entire country that are in the same boat as you. So even if you may have political or ideological differences with your colleagues, those political and ideological differences are going to be set aside a lot of times when it comes to personal interaction. And they're going to be cordial or friendly with their colleagues because those are their colleagues, right?
They're their colleagues. And I still hold high to the faith that the Supreme Court is non-political. As much as the media makes it sound like it, I go back to some recent decisions that have been made by the Supreme Court, in which you saw President Trump's 3 appointees that many people would say, well, they're going to be so right-wing, Republican, conservative, where those 3 individuals have acted against the best interest, if you will, of that political party. Yeah. Where, especially when it comes to vaccines and mandating vaccines and all of these different things that were being talked about and the COVID issues, I think you're seeing that these justices are truly about what the law says and how the law protects the life, the liberty, and the pursuit of happiness for all individuals. So if listeners focus on the wording of the opinions of the court and the actions of the court, I think it might give us a little hope that all of this minutia that's out there about they don't like each other, about this, about that, isn't really true, that they're acting as to what the law says. And I have confidence in that.
Yeah, what they believe the law says. And that was, I think, one of the most important things that came out of the Convention of 1787 in Article 3, Section 1, where it says, they shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. In other words, what the framers did was they removed these justices from the world of politics. They said, your job is not dependent on those politicians. Your pay is not dependent on those politicians. So now you theoretically can go to the court and you can make the rulings that you believe are correct. Now, of course, your personal beliefs and things will still impact your views. And, these people, they have cable TV, they listen to NPR, whatever the case may be, and they can be influenced by that. But they can be as separate as they want to be from the political day-to-day mudslinging, as it were.
Yeah, and it is for our listeners over the next few weeks to really pay attention to how this process plays out. I'm pretty confident that the person that President Biden selects, he's going to, long before he selects them, he's going to have the support behind the scenes of the main leaders of his party in the Senate that he's going to know you have a really good chance to get this person through. Don't you think that he's going to know that there's a pretty good chance that the person gets elected before he even announces a name?
Yeah, because the last thing you want to have happen if you're Joe Biden or any other president is to have a candidate voted down. We talk there about Robert Bork. In 1987, he was put forward by President Ronald Reagan to be on the Supreme Court. He was defeated 58-42 in the Senate. It was not a party line vote. There were 6 Republicans who opposed him and 2 Democrats who supported him. But there were serious questions about Bork's commitment to certain civil rights rulings on the Warren Court and the Berger Court. So he was knocked down by the Senate. They advised nope, and they refused to consent to Robert Bork's nomination. And then you move as recent as 2005, when George W. Bush, before he nominated John Roberts, I believe it was, he had nominated a lady called Harriet Miers. And Miers was a White House counsel, basically a lawyer for the White House. And she was nominated, but people, I believe, on both sides of the aisle, and correct me if I'm wrong there, Chris, said, what are you doing? I mean, this lady doesn't have the judicial background to really fill this position. And so she withdrew, I believe she withdrew her own candidacy. And if you're president of the United States and you're nominating a candidate, you don't want them knocked down by the Senate, and you don't want them to either withdraw themselves or you to have to withdraw them, because that's pie in your face.
Yeah, and pie in the face. One last story I'll share. It kind of has North Carolina ties since we're here in North Carolina. It goes back to 1930 when the Senate did what they really don't do a lot, and that is that they rejected a Supreme Court nominee. And I thought it was interesting because in 1930, you have Herbert Hoover. He's the president during that time. And in 1930, not one, but 2 Supreme Court justices pass away. And so he has the responsibility of nominating 2 people. And he nominates the first one. His name was Charles Evan Hughes, and says, hey, I want you to fill the vacant place of the Chief Justice. Well, you wouldn't think that would be a big deal because he was a former Associate Justice. So you would think it would be easy. We'll approve him. However, he doesn't get approved for many reasons, but one of the reasons they don't approve him is because Charles Evan Hughes had resigned from the Supreme Court, and he resigned so that he could go and possibly run for a Republican presidential nomination back in 1916. And they were like, why am I going to put somebody back on the court when you had that job? You resigned to go fulfill your own aspirations. No, thank you. That was your one moment and you didn't do it, so you're done. And so, many people are really debating this whole thing. However, he does get confirmed. So very, very small margin, but he gets confirmed. But what happens with that is 3 weeks later, that second justice dies. And Hoover said, oh, I've got an easy selection this time versus the one that I had with Charles Evan Hughes. And so he decides to nominate a very prominent Republican whose name was John Parker. And John Parker was from North Carolina and was actually the chief judge of the Fourth Circuit of Appeals. And here's where that background comes in, Ray, because 2 actions by Parker in his previous roles prevented him from becoming a Supreme Court justice. Years and years earlier, he had given this anti-labor speech. And so it infuriated a specific group of people. And then go back even further, I think it was 13 years before, he was, and there was this campaign for governor of North Carolina, and John Parker responded to what they called was race baiting prediction by his opponent. And he said something that he shouldn't have said. And basically that comment stuck with people because it was put in the newspaper. It was reminded by people. And because of that comment and something else, he doesn't get elected to the Supreme Court, or doesn't get nominated and approved to the Supreme Court by a vote of 41 to 39. 2 votes, all because of 2 missteps that he said years and years ago. So if you want to be a Supreme Court justice, you got to have a clean record from the time that you first put on diapers.
Yeah, you've got to keep it clean. And just one more story. And there's several parallels as I'm listening to you talk there in what you just said to what I'm getting ready to talk about. A lot of people don't know, I'm sure, that the first Supreme Court nominee to be rejected by the Senate was actually put forward by guess who?
That would be Father George.
George Washington. In December of 1795, George Washington put forward John Rutledge. Well, actually, it was before December of 1795. John Rutledge, of course, had served in the Constitutional Convention. He had been the governor of South Carolina. This man had a good reputation. But what had happened was he had originally been nominated to the Supreme Court by Washington in 1789 as part of that inaugural court. And he was approved by the Senate. Well, he resigns, as you mentioned the other guy had done, to go to serve on the South Carolina Court of Common Pleas and Sessions. Okay. And then in 1795, Washington renominates him for the Supreme Court. And Washington doesn't just renominate him, he actually places him on the court as a recess appointment. In other words, the Senate is in recess, so Washington just sort of puts him on the court, I guess, assuming it would be an easy thing to get. Well, the Senate returns, and in December of 1795, they vote to no, you're not coming back on the court. He is turned down. And he is the first Supreme Court justice to be rejected by the Senate. He's the first recess appointment. And there have been, I was doing research, Chris, there have been numerous justices of the court that were initially appointed as recess appointments. And then the Senate later came back and approved them. But Rutledge was the first one to be rejected by the Supreme Court. And the question is why? What happened? 2 things happened. Number one, he had gone out in the summer of 1795 before he was renominated and spoke out harshly against the Jay Treaty, which was a treaty that John Jay had gone to Great Britain by George Washington's direction and had worked out with the British, trying to resolve some issues between the United States and Great Britain. And of course, many people were opposed to that treaty, and apparently Rutledge was one of those people who was opposed to the treaty. So the Federalists, who of course George Washington was a Federalist, they started spreading all sorts of rumors that Rutledge he was an alcoholic, that he was mentally ill. All sorts of rumors began to fly about Rutledge. So by the time the Senate comes back and they see this guy on the court, nope, not going to fly, and they turn him down. So you talk about, keeping your record clean if you want to be a member of the court. And by the way, when all this was done, he attempted suicide. He tried to he did jump off a wharf into the Charleston Harbor. And believe it or not, he was saved by 2 slaves who saw him in the water, and they dove in and pulled him out. And after that, he's just going to pull back from public life, and he's going to die in 1800. But, like you said, anything you say and do or write in your career, if you're nominated for the Supreme Court, can and will be used against you.
Anyone who is a aspiring judge or a lawyer or anyone wanting to be in that career field, the highest place is in the Supreme Court.
Yeah.
But it is the most difficult place to get. Only 9 spots.
Yep.
And you serve for 20, 30 years. Doesn't come open much. But the scrutiny behind a Supreme Court judge is so much more than a senator or even a president.
Mm-hmm.
So the next few weeks is extremely important for our nation to pay attention to and to understand, because they will have a long role in shaping the course of American history. So I hope our listeners maybe they'll gain some information through our podcast. And then when President Biden selects his nominee, they'll know how the process is going to work, but they also know why it's important for us to do our due diligence and research and understand how this process works out.
And a little trivia, did you know there was one president who was also Chief Justice of the Supreme Court?
Yeah, he was a big guy.
Yeah, William Howard Taft.
And that's a whole story in itself.
That is. So I'm not going to talk anything more. I'm not going to say anything more about it. We'll do a podcast on it.
I think that's great. That'll be exciting.
Yeah, a little teaser.
Yeah.
Chris, I've really enjoyed this episode. It's a little longer than a normal episode, but I think this is an important topic for us to sort of cover the various different angles. And I hope our listeners enjoyed this episode. If you have any comments, questions, or suggestions, you can always email us at historyyousshouldknow@gmail.com. That's history, the letter you should know, @gmail.com. We encourage you to find us on Facebook, on Twitter. We encourage you to share this podcast with your friends. We're on Spotify, Sounder FM, Google Podcast, and others. Share the video, share the episode, and tell your friends about history you didn't know but should. Until next time, I'm Ray.
And I'm Chris.
And we will talk to you later.